Next case on the calendar, Silver Beach Investments of Destin versus Silver Beach Towers East Condominium. Counsel, you may come forward.
May it please the Court. Good morning. My name is Stanley Bunner, and I represent the appellant, Silver Beach of Destin. Your Honor, the appellant today contends that the trial court's final judgment in association case ordering specific performance should be reversed, and the reasons are threefold. The first is that the underlying order granting summary judgment on the count for specific performance should be vacated because the trial court improperly modified the underlying contract rather than a document purporting to evidence the contract, and also that it chose to reform the contract and then order specific performance of the reformed contract. Such action is specifically forbidden under Florida law, and subordinate to those issues.
Wait, let me ask you this. Did he just put it back to where it was before the amendment? Is that what happened? Is that essentially what we have here? We have the contract, then we have an amendment. The judge puts it back to the pre-amendment contract.
Your Honor, I would say that the declaration, there was a certain unrecorded declaration attached to the contract that was incorporated in. And what the court did, in effect, is have the declarant convey the beach pursuant to that original unrecorded declaration. So to that extent, yes.
So essentially that's the case. I mean, it was.
Well, Your Honor, I disagree with that characterization that essentially that's the case. What happened was, in order to get there, one has to excise Section 13.10 of the declaration,
which was the section that deals with.
That was a specific provision that the developer put in, putting the buyers on notice that at any time before turnover, the declarant could alter the boundaries of the common properties and, in fact, remove properties from the common element in this condominium.
And you're arguing that that's not contrary to the statute that requires notice to the condominium owners.
Your Honor, there is some conflict in that even in the contract itself, there are other portions of the contract that state that certain things will be done with notice. So then the question becomes, what happens if that notice is not given? What is the remedy? And within this argument is that the remedy is not to strike a provision of the contract. There's no case law out there that says it will strike.
What would you say the remedy was? Rescission of the contract? Tell these people they have to leave these condominiums they've been living in for several years?
There are two available remedies. There are two available remedies, Your Honor. The first would be rescission for those who choose it, either before signing, because there's a 15-day window, or after closing if they so choose. And also there's a remedy in damages. And there's a case in my brief that I cited, the Welch case, wherein a developer had placed in the condominium declaration that a certain unit would be a manager's apartment, and then the declarant revised it and sold that manager's apartment to a third party. The court there rejected the concept that the condominium owners could, after the fact, come in and use that unrecorded instrument and have it prevail over legal title to the property, because the court said simply as a matter of policy that it would throw condominium titles into a state of disarray and potential chaos. So the court there said that the proper remedy for those.
Wouldn't that happen here? And this is a little different situation because we're talking about title to the condominiums by all of those people who purchase the condos with the expectation that they would get what they signed up for.
Well, in that regard, Your Honor, I don't think that Welch is distinguishable from the instant case. I think there are aspects of Welch that are distinguishable from this case, but I don't think that's one. Because both in this case and in Welch, one could say the same thing, that those who signed the contracts believed that the manager's apartment was going to ultimately be a common element.
But I'm assuming these condominiums have accumulated in value over time. Then wouldn't it be a detriment to the homeowner to rescind the contract, lose all the value in that contract, in their condo?
In the event that the condominium increased in value, Your Honor, a rescission might not be a wise choice from a business perspective for the owner, in which case the owner would then choose his damage remedy.
How would it be an effective remedy for the homeowner if they're losing
Well,
substantial value in their property, which they have been in for a substantial period of time, to rescind the contract?
Well, as I said, Your Honor, as a business decision, that might not be wise. But then the damage remedy is there. The damage remedy is available to them. They can choose remedies, one to the other. I mean, they can file under two different theories, one being damages, one being rescission if they so choose. But there ultimately is a remedy. Certainly, there's a maxim that for every wrong there's a remedy. But I think equally can be said that not every wrong deserves every remedy. And I believe the case law here is clear.
This is why we have specific performance, all right, as a remedy.
I'm sorry, Your Honor?
This is why we have specific performance as a remedy.
However, Your Honor, specific performance must only be on the specific terms of the contract. And that is clearly set forth in three cases that I brought to the Court's attention. The first is Heisler.
Let me ask you this. Are you saying that at no time, you're not saying that at no time the condo owners had no expectation of beachfront ownership?
I do not challenge, Your Honor, the concept that owners may have believed that they were buying the beach.
Well, what do you mean may have believed?
Well,
They were buying it at one point, correct?
well, Your Honor, there's no evidence.
Until the declaration was amended.
Yes. I understood the Court's question to be, what do I understand the buyers to have believed? I can tell you that
Yeah, but I mean,
the documents
in fact,
stated the beach would be conveyed.
Exactly.
I believe that certainly that, and that was decided in the trial court.
The declaration was material change in the original declaration?
Your Honor, I don't believe there's a material change, and the reason for that is, as is set forth in the Wellington case that I provided to the Court. In the Wellington case, the Court said, and that case dealt with whether or not a developer could use a general amendment provision in a condominium declaration to remove common properties. And the Court said, no, that is not allowed. However, the Court then did say, and I will quote it, if at the time of purchase the declaration or bylaws provide how and under what circumstances the common elements may be altered, the purchaser takes subject to such provisions. And that's the key. What's required here is notice to the buyer that there may be an alteration to the common properties. That puts a buyer on notice that if the common elements, if the common properties are material to their decision to purchase this unit, that they should be aware of this contract, because in this case the developer has reserved the right to change it. There certainly may be contracts out there. There may be one a half a mile down the beach where the developer does not include a provision that may change and remove the beach.
but you're saying he never has to notify them because it's not a material change.
No, there was a notice requirement, Your Honor. There was a notice requirement. However, the notice was not provided. What I'm saying then is the remedy is not specific performance. It is damages. That is the remedy. That was in Welch, we had that same situation. The buyers closed in escrow without notice of the change, and then after the fact, long after the fact, they discovered that the manager's apartment was not a common element, and they brought suit. The Court there said that the remedy is damages. It is not a revision of the contract and specific performance. So the case law of specific performance clearly shows that the remedy was not proper here. The Supreme Court of Florida in Heisler v. Florida Mortgage, Title, and Bonding Company stated that it is not within the province of a court of equity to rectify contracts. And then in Schwartz v. Zakonic, later on, they said that equity, although not as inflexible as law, is nevertheless administered within the established limits upon recognized principles. That brings the case of Geiler v. Ward. In Geiler, a seller conveyed property, a business, and real property under it, and agreed to not compete with the buyer's business for a period of 3 years from the date of the deed. In fact, it violated that covenant. In fact, it even violated an injunction related to that covenant. And the buyers came to the court and said, what our true deal, our real deal, the true terms, was a 3-year period of non-competition. So give us an order of specific performance that they may not compete with us for 3 years. The problem at that time was when the case was in the trial court, the 3-year period from the time of the deed had expired. And the trial court said, we cannot do that. We can only specifically perform a contract on its very terms. Those terms have expired. Your remedy is in damages. And the appellate court affirmed that judgment and commended the trial court for only compelling specific performance in the precise terms agreed on by the parties themselves.
Counsel, let's digress back to the Welch case.
Yes.
If we will, for a second. In this case, the common element, the beachfront lot, produces continuing revenue. Is that correct?
The beachfront, yes, the beach can be rented.
Yes.
Someone can operate a beach concession service.
Did the common element in Welch produce continuing revenue?
On the facts of Welch, no, Your Honor. I don't believe it did, because I believe it was sold.
Would you say that is a major distinction between the two cases?
I do not, Your Honor, because the common element that was then transformed into a developer property, it could have been rented. What if the developer had chosen to rent it rather than sell it? I don't see that as material. I understand where the Court's going with that, but I don't see that as material. Another case is the case of Edland v. Seagull Townhomes Incorporated. Again, there, the trial court erred in disregarding the specific language of the declaration. What the trial court did there is it ordered an owner to convey a piece of property, the condominium, to the association because it had disregarded the association's right of first refusal. But, however, the declaration itself provided the owner the opportunity to reject the association's offer. And the Court skipped over that step. It said, you wrongly conveyed it, therefore we're ordering you to convey it to the association for market value. Then the appellate court said, no, you can't skip over that extra step. The property conveys back to the seller, and then they have the choice then to give it to the association or not.
Counsel, before you run out of time, be
Yes.
sure to discuss, my greatest concern is the damages issue.
Yes, the damage issue. The damage issue here was wrong both procedurally and substantively. The procedural aspects I'm going to leave to the brief since we're fairly brief on time and go to the substantive issue. The substantive issue there is the case law says in Weiberg v. Eisenberg, for example, that damages awarded incident to the decree of specific performance are clearly different from those which would be awarded in breach of contract. So there must be a difference. Kisman v. Panisi then says that the measure is the yield of the property via rents and profits. What does that mean as a practical matter? And what the Court then said in Kisman is what the Court is really requiring is an accounting in its attempt to adjust the equities. Where does one find the methodology for an accounting of rents and profits of real estate? I contend in the brief it's Anderson v. Northrop, which dealt with the accounting for real property. There were 3 sections, Winslow Cottage, which was rented the whole time. The Court said that the measure would be the rents less operating expenses. Markland Cottage was only rented part of the time, and the Court rejected the magistrates deciding that it would just apply a broad measure of damages, an average measure.
So what was done in this case, and why was it wrong?
Well, first, procedurally, it was never noticed for trial. We had no idea that damages to be pursuant to specific performance were even under consideration until after both sides had rested. What happened here is...
Well, did he actually grant damages? The damages look more like a breach of contract damages than a specific performance
Well, if it is a breach of contract, Your Honor...
I'm asking, is it?
No, I don't believe so. I believe he, after the fact, called them incident to specific performance.
But how does he come up with the amount?
He accepted a mathematical, a hypothetical model from an expert witness, rather than using the books and records of the beach itself.
But what were they? Were they what they would have generated had they been operating?
In theory, it was what they would have generated. It was this man's hypothetical mathematical model of what could have happened.
And your position, so I understand it, is that assuming you could get specific performances and damages incident to that, it would have to be limited to the profit that was actually made.
Yes.
By your client on the use of the property in the interim.
That is our position.
Which is
yes,
in the
Your Honor.
record?
Yes, Your Honor.
How much is it?
The amount that we did make? Oh, I don't know that answer, Your Honor.
I mean, is that in the record?
The evidence is in the record, but it
No,
wasn't.
but I mean the amount. The actual
amount
amount.
is in the record. The
Okay.
amount could be computed from the evidence that's in the record.
Okay.
Yes.
So, Counsel, your point is we assume that the appellee properly pled damages for specific performance in the complaint, and that damages for specific performance was properly noticed for trial. Then the trial court's award of $1,148,362 as damages was not incident to an award of specific performance.
It would be the wrong measure of damage, Your Honor. The damage measure that was applied by
the appellee would only be entitled under specific performance for damages for profit.
Yes, for the actual business operations of the beach. And accounting is what actually took place, not what somebody hypothetically thinks could have taken place if things had been differently. That's our contention. If I may just reserve the last little bit for rebuttal. Thank you, Your Honor.
Good morning. My name is Simon Bloom. It's my honor and privilege to represent the appellees in this case, which are the Silver Beach Owners Associations, East, West, and Master. This is a case about a breach of contract. 1310 is a red herring. This is a case about somebody that promised to deliver the backyard to the house in the contract, decided the day before closing to take the backyard out and to deed it to somebody else, and then went to closing without telling anybody that he deeded off the backyard. And you find out 5 years later, and you don't have a backyard in your record title.
And what about his argument that you have 15 days once you find out to rescind the contract?
It goes right to Judge Lewis's point, which was this was 4 years later before anybody found out, 3 years later before anybody found out that this had actually happened. So you have owners and you've had flippers in Destin where you've got 2 or 3 later that actually own the house or own the condo and come to find out that they're supposed to now rescind.
Well, are any cases, any of these rescission cases analogous to what we have here?
No, ma'am. No, ma'am. I mean, there aren't very many that I can think of, any cases, in fact, where rescission was required. Rescission is an option. But the key to the rescission question that we've glossed over for some reason is that rescission is triggered based upon materiality. There's notice and there's materiality. The statutes clearly require and the contract requires you give notice of any change. Florida Admin 61B 17.006 says you've got to give notice of every amendment. This contract, Section 19, says you've got to give notice of every amendment, regardless of whether it's material, regardless of whether it's adverse. That gives the owner, and this is to your question, Your Honor, that gives the owner the right then to say, I think that's a material change, and my remedies are rescission, damages, specific performance, equitable reformation. There's nothing, there's no case in this state that limits the field as to what remedies these owners had or have as a result of the inequitable, improper, and illegal conduct of the developer.
What do you say to their argument, which they didn't make an oral argument today, but they made in their brief about Rule 61B-17.0062D3D?
Yes, ma'am. 2D3D, as we call it. Yes. 2D3D wasn't in effect at the time these documents were recorded. 2D3D, more importantly, and this
would it even change the result of this?
No, ma'am. Not at all, because as I was saying, 2D3D speaks specifically to whether a change is or is not material. Right. It has nothing to do with notice. It has nothing to do with whether it changes the notice obligation in 006-1A.
Well, the notice requirement says notice of a material change.
No, ma'am.
Okay.
No, ma'am. The notice requirement in the contract itself.
Notice of any amendment.
Any amendment.
Okay.
And this is really, really important. 17.006. I'm sorry.
You're right.
Says any amendment you've got to give notice. And then in 18.001, 3 and 4, it reaffirms that. It says once you've given notices of any amendments per 006 up above, you then have to certify to the closing, to the purchasers, the fact that you've given them notice of all the amendments. And you have to give a written certification giving them the right to rescind, again, if they feel that the change is material and adverse. So the statutory construct is really, for a change, very congruous. And it reads together all of which points to a requirement for notice.
Counsel,
yes, sir.
Counsel relies on the Welch case in support of his argument regarding Pacific Performance. Can you distinguish the Welch case from this case?
Yes, sir, Your Honor. And your original distinction was a good one. The revenue production issue is a good distinction. There are a couple other important distinctions. Number one, let's be very, very clear. The Welch case does not in any way, shape, or form preclude specific performance. What it says is, in the second to the last paragraph, that you have a right, you owners who have not yet closed, which is something that got glossed over, have a right to damages. Well, that's clear in the statute. The statute in 17.503 says you have a right to damages for fraud or misrepresentation in the condo docs. But nowhere does it say you can't get specific performance. Now, there are factual distinctions. This was a quiet title action in Welch. We didn't have a quiet title action. We brought breach of contract, DJ, specific performance, and damages. We didn't bring a quiet title action. We went back to what we thought was the original problem here, which was that there was an inequitable conduct and a unilateral mistake of fact. We had all these owners that thought they were getting a backyard that found out that they didn't, that the developer violated the law in all the instances I've described, and that's the inequitable conduct. And we say to the judge, these are all you need. to get the straight line from A to Z, A being here's the liability, Z being what's the remedy. And in this case, it was not an easy straight line going through the 3 years of litigation. It hasn't been. We've been up here once on this, not on this exact issue, but definitely dealing with 1310. 1310 is a red herring. This court can affirm the trial court's decision on both liability and remedy through three different ways, three different routes. Route number one, this court can conclude that simply Section 19 of the contract is all that matters. You had a more recently negotiated, signed, more specific, which as the court can identify when you do the rules of construction, you've got a more recent and more specifically directed contract provision that says if you change anything, you must notify all purchasers, period. So you can use Section 19 to find that there's been a breach of contract, that 1310 doesn't even come into play. 1310 may or may not be in contradiction to Section 19 because I'm not quite sure, and I think this court, I humbly suggest, consider whether the declaration of restrictive covenants that contains 1310 is necessarily incorporated by reference into the purchase agreement. And the Jenkins court case talks about that, and I think that's a threshold question. Because if it's not part of the purchase agreement, if all we've got is the purchase agreement, then Section 19 sits by itself. You didn't give us notice. You violated 19, game, set, and match. We're done. Now the court has specific performance remedy arising out of a simple breach of contract. Yes, ma'am?
No.
Oh, okay. The second way it can do it, obviously, is through equitable reformation. Inequitable conduct, unilateral mistake of fact. Here we have the effort of the trial court acting in equity to place the parties back to what the original agreement was, which was Judge Davis's original point. Didn't this court just put the parties back to where they began with an understanding that they were going to get a backyard? That's exactly what this court did. And that's a straight line that this court relied on. The final thing, of course, is that this court can confirm what was not necessarily dicta, because it depends on whether you read the summary judgment order or the final judgment or both together, which I think you have to do. And that is a determination that the conduct of the developer is in violation of Florida law. Now, that's different from 1310 being in violation of Florida law, because 1310 clearly is in violation of Florida law. But that the conduct of pulling the beach out without notifying anybody, of amending the declaration without notifying anybody, in and of itself violates Florida law. And this court has, in several instances, in the Winkleman case, in the Bayview Buick case, in instances where there's severability provisions, and this contract had one, and instances where you find an arbitration provision is for some reason void as a violation of public policy or in contradiction of a statute. There's just countless instances where a court can look at a contract and find that one provision is in violation of public policy or in contradiction to a statute and conclude that that provision is not effective. You don't need to get there here, but it's just another reason that this trial court can be affirmed for the decision in the way that it got from liability to remedy. The question of Welch, I think we've addressed. The argument that I understand that the appellant's trying to make with respect to your trial court modified the contract and then specifically performed or ordered the performance of a new contract. Let's talk about that for just 1 second. If the law is, step A, equitable reformation is available to return the parties to the exact initial agreement, we agree, yes. Step B, if a trial court can order specific performance of the exact agreement that the parties agreed to, notice the similarity between those two factual predicates, then, therefore, this court can order the parties to perform the exact contract that they originally agreed to. It doesn't skip any steps. You go through one step at a time.
The third step, though,
yes, sir.
In reference to count 2, your claim for specific performance, did you specifically seek damages for that claim in your pleadings, your complaint, or amended complaint? No, sir. We did not. And it is our position that... Are you entitled to that for what you did not seek? Yes, sir. And why? Because Florida law allows the evidence... Did you amend the pleadings at any time during the course of proceedings? No, sir, we did not. We did not. This is, and the way it played out, first of all, to answer your question directly, pleadings may be amended in equity to conform to the evidence. At the end of
the February trial, the evidentiary trial on damages. We came to that trial, we put on evidence of damages. First of all, the measure of damages for breach of contract in this case and damages incident to specific performance are identical. Their own expert in the record said, we said, what are you valuing? He said, I'm valuing the lost rental. I'm valuing the lost profit.
So you sought damages in your pleadings for breach of contract?
Yes, sir.
You did not seek damages for specific performance?
Correct.
The trial court awarded damages for specific performance, even though you requested damages only for breach of contract.
The only thing I would respectfully amend to that last statement is only for, because as all complaints do, there are general damages requested and there's a general remedy section requested in the wherefore prayer, and that was contained in this complaint. More importantly, though, and
So your saving clause here, a saving grace, is your wherefore clause in your amended pleadings.
and more importantly than that, more importantly than that, the judge at the end of the trial said, I've got a concern about the measure of damages and whether we're going to be walking ourselves into a buzzsaw. The appellants didn't raise this issue. They said, I want to make sure we're not walking into a buzzsaw. You all go out and brief the question of whether the measure of damages for breach of contract is the same as specific performance. And the point is, if in fact they are, we don't need to have another trial. That was exactly what happened at the end of the February 26, 2008 trial. Because he recognized, and I think astutely as Your Honor's pointing out, that if there was no specific request for damages incident to specific performance, but yet that could get us there, let's do what makes common sense and judicially efficient, which is you all brief it. There were 3 rounds of briefing, another set of oral arguments, and another opportunity to object to the final order.
And no objection to an award of damages, only to the amount?
Not until, in all fairness, in July, this is 5 months after the trial, in July there's an objection made to the issue that Judge Lewis is bringing up, in all fairness.
And did you respond that it was a general claim?
Yes, ma'am. Yes, ma'am. And we responded just like I'm responding. Yes, sir.
So it's not a waiver issue, per se. You have protected yourself by your wherefore clause in your amended pleadings. That's what you're saying.
Both. Well, we're not arguing waiver. To answer the first part of your question, the wherefore clause protects us, and there was absolutely no prejudice or surprise to the appellants because they had an opportunity to have 2 more rounds of briefing, another hearing, all before any order came out of the trial court to address this exact question. And the essence of it was that the judge concluded that since the measure of damages for specific performance and breach of contract were identical, when you have the temporary suspension of ownership rights in a piece of dirt, that there is no need to have a new trial. So harmless error is what I would offer as my third argument.
So, counsel, is the measure of damages for specific performance different than that would be awarded for a breach of contract action?
No, sir. It is the same.
How could it be the same? In one case, you've got the land back. In the other case, the court is attempting to compensate you for the loss of the land. I mean, how could they possibly be the same?
Time. In the second case, you have the permanent loss of land. So the measure of damages is not just going to be how much did you lose over the last 3 years. The measure of damages for a breach of contract without specific performance is how much do you lose because you never get the land back. And it's a completely different analysis.
Well, I understood this discussion to be about this point, to be the objection to be that damages incident to specific performance have to be limited to the profits actually made by the party in possession, whereas in this case your experts presented testimony based on modeling about what could have been made had you owned the beach as you should have. And the argument is that was not correct because that's not the correct measure of damages. It has to be limited to what the possessor earned. So what do you say to that?
And
you disagree with that, I guess.
Well, we can agree, Your Honor, and I can agree that that's a different point than the earlier point, which was whether breach of contract and specific performance damages are different. Because in Your Honor's...
Well, you've answered that question.
Okay.
The difference is really just the question of time, isn't it?
Yes, sir.
But if I understand the argument correctly, there's a difference in the way the damages are calculated, computed.
Yes, sir.
You can't come in with some expert who said, now look, if the owners decided to put a wild mouse ride on that beach, they could have made $15 million, and you can't do that. if I understand the argument correctly.
That's their argument.
Okay.
And my response is as follows. Number one, the standard of review is different in that regard. What evidence the trial court finds, sitting as a trial fact, to be more compelling and more convincing about what the actual damages were, receives a great deal more deference than a de novo standard. That's response number one. Response number two is that the evidence of the profits or rents that they put on at trial, this is critical, was from an outside third-party vendor that was a related entity to the developer, i.e. the owner of the beach, that was running the beach concessions, chairs and umbrellas, making money off of chairs and umbrellas. The difference, and this is a critical difference, is that it wasn't what the developer, as owner of the beach, was making. Because the lease between the owner of the beach and the third-party vendor was for $1. So there was no money flowing from the third-party vendor taking money on the beach for chairs and umbrellas going to the owner of the beach. That, in connection with the fact that the evidence is replete with instances where the third-party vendor, was actually the son of the developer, owned that third-party vendor, that was running the beach service.
Was the award based on the actual amount of profit that somebody made as opposed to the profit somebody could have made?
It was the latter.
Could have made. And
Correct.
why is that not wrong?
It's not wrong because we project lost profits all the time when we're evaluating the
But
profit.
if I understand correctly that you're not supposed to do that with damages incident to specific performance.
No, sir. No,
That's
sir.
not correct.
I don't believe that's
Okay.
correct.
What's the
Yes, ma'am.
difference? What's the difference? What's the difference between here, the profits that were actually made, and your testimony, what could have been made from this property?
The difference is that there's no evidence in the
Oh,
record.
an amount.
I'm sorry.
We have no idea an amount. What the difference?
It's an order of magnitude because, and that's
$1 million?
Sorry?
$1 million? $10 million?
Difference?
Yeah.
No, ma'am. The evidence that was in the record included these books from this third-party vendor that it was, the net income was several $100,000 over the course of these 3 years,
Like
roughly.
$560,000 or something like that.
I'm sorry.
About $600,000 or something?
I think it was less than that, Your Honor. I think that the third model well, it may have been $600,000.
Is that what they want to limit the damages to?
Well, I think they'd have to. If their only argument about the damages is the fact that they got the wrong number because they used what the model said as opposed to what this third-party vendor actually earned in net income, they'd be, our bottom bracket would be that number. But we don't believe you get to that.
Is there record evidence of the profits that the developer actually made during the period in question?
It would be the $1 a year. It would be the lease payment, because none of the money that went to his son flowed back to the developer. And that's precisely why, one of the reasons the trial court rejected that as a method of measuring damages. That, and we pointed out that those books were so cooked that the turkey popper had already gone off. I mean, he was running his boat out of that business. He was running another beach operation out of that set of books. He was running his personal stuff out of that set of books. And we dismantled that measure of damages because it was completely suspect.
Okay.
Yes, ma'am.
Walk me through what measure of damages you presented.
Yes, ma'am. We took the model where the association owned the beach, predicated on the notion that the association has been planning for the past 5 years to own the beach again, and their plan to operate their beach service would be done by themselves. They wouldn't hire a third party. This is all on the record. The record evidence testimony was that if we owned the beach starting in 05, we would hire an in-house guy, which would be much cheaper, and he would put out chairs and umbrellas. This is not rocket science. And we would collect money. And the model was, if you assumed the usage that was taking place over those past 3 years, going back, all retrospective, what would that generate in revenue compared to what would our costs have been? And this is all this is not like how many widgets are you going to sell.
Is it common practice for the associations to actually run the beach themselves or to contract it out to a third-party source?
It is more common to do the latter, but it is not unheard of to do the former.
Okay.
I just didn't want to adopt the common practice. Judge Lewis.
Okay.
Thank you very much.
Your time is short, but
Yes, Your Honor.
our counsel ran over, so I'll give you 3 more minutes in
Thank
addition.
you, Your Honor. Your Honor, a trial should be about what happened, not about what could have happened. I contend that a tipsy coachman can't get the appellees to where they want to go. And there are a number of reasons why. What the trial court did here is it took, exactly as this argument was presented here today, it took bits and pieces of a bunch of different causes of action, mixed them all together and said, therefore, give us the beach. Let me give you an example, if I may.
Focus more on damages at this point, if
Well,
you will.
All right, Your Honor, first of all, I would say that there is nothing either in the judgment or in the record wherein the court said anything about rejecting the books and records of the beach service. It just isn't there. And to contend otherwise simply is not supported by the record. The court did not reject the book and the records of the beach in favor of the mathematical model. That is simply not what happened at trial.
So based on that particular measure, what would be the measure of damages?
Well, if you look at the Northrop case, I believe it would have to be the net business proceeds of the beach service, the third-party beach service.
And what was that?
That, I don't know that exact number, Your Honor.
Is it in the record?
Yes, it is in the record. The books and records of the beach service is in the record.
Okay, were we to remand this case to the trial court,
Yes.
saying that he used the wrong, well, that it didn't appear that he used the correct measure of damages, could he at that point reject the credibility of your witness or require further proceedings and determine that what your opposing counsel said, that evidence was unreliable for many reasons?
Your Honor,
come up with a different figure. I mean,
I'm sorry.
what would happen?
Your Honor, I believe if this court were to remand it on the issue of damages, solely because, first of all, you can't have a trial and then after the fact say, gosh, what did we have a trial about? Let's brief it and figure it out. It's not surprising that the conclusion was, well, yeah, the evidence we took was okay. We don't have to have a new trial. I think in this case, because it was done backwards.
You'd have to have a new trial on damages, is what you're saying.
I believe that everything would be wide open again. We would have to do it again. We'd have the proper measure of damages established. We'd have evidence going toward that legal standard, and obviously he could challenge the books and records. We would be back. Yes, we would have to do that.
And your argument about what counsel said about all the extraneous items would be that if the judge believed that there were extraneous items, somebody's personal expenses or boats added in there, to artificially deflate the profits, that those would have to be put back in.
Absolutely. That would be perfectly proper. But if I may speak again, though, to the issue of rescission, because, again, this is key. The fact of the matter is, if you look at we've heard 718-503 prevents as material and adverse. It couldn't be material because that put the buyers on notice that it could be changed. And for that matter, under 718-503, rescission is the express remedy. There's absolutely no 718-503 jurisprudence that rescinds the amendment. The effectiveness of the amendment is never challenged. The amendment stays. People get certain damages. They can either rescind their purchase and sale agreements or they can get damages. But the amendment is not rescinded. Again, in Section 19 of the contract, he says that you had to give us notice. Fine. But there's no case law in the state of Florida that says if you violate the notice provisions that the amendment is rescinded. There simply is no case law to support that. The measure, and in fact the express sole remedy under the contract, is rescission. And then under the administrative code, and that was a good point, the change in the administrative code, it can be even applied retroactively, because as Judge Panavato, I believe you said in your case Environmental Trust in 1998, if the rule is changed and it only clarifies an existing rule, it's not new law.
But the legislature kind of slapped that down, though,
With
didn't it?
12054-1F, saying, no.
I mean, I still believe that that's a proper interpretation. It was based on a United States Supreme Court decision. But
Yes.
our legislature chose not to accept that.
Well, again, 718-503, there's no case law supporting rescission. You can't specifically perform a contract if you've changed it, and that's what the court was doing here today, or did at the trial court. And under the administrative code, there is no rescission of the amendment. It's simply damages under Welch. Thank you.
Thank you, counsel. Thank you both.